Sergeant, we're ready to go, right? Did he say yes? Oh, gavel, yes. Good afternoon. I am Jim Gennaro, Chair of the Committee on Environmental Protection, Resiliency, and Waterfronts. Today we're here to examine the Department of Environmental Protection's response and management to noise complaints. The committee will also hear a few pieces of legislation, including intro number 160, sponsored by Councilmember Holden, in relation to the noise standard for commercial businesses. Intro number 1194, sponsored by me, in relation to citizen noise complaints, and a package of bills sponsored by Councilmember Powers, that should be Majority Leader Powers, in relation to construction noise, noise inspection results, and creating a photo noise violation monitoring device program for motor vehicles. New York City must balance the vibrancy of being a world-class city with the needs of everyday New Yorkers. However, DEP cannot always respond quickly to every noise code violation in the city. To that end, sip of tea. To that end, the city's noise code allows New Yorkers to file their own noise complaints against violators of some, quote, some noise code provisions. These civilian enforcers must first serve a complaint upon DEP. Then, if DEP fails to act within 30 days, the enforcer may file the complaint directly on the alleged violator and the Environmental Control Board in the Office of Administrative Trials and Hearings, known as OATH. Civilian enforcers are awarded a percentage of any penalty assessed from a complaint they pursue, that is, if it's upheld, typically between $110 and $660 per complaint, staff informs me. Engaged New Yorkers play an important role in the enforcement of our city's noise code. However, recent news reports have highlighted a small number of civilian enforcers who file large numbers of complaints under one particular noise code provision, often repeatedly against the same businesses, to collect the award money. The result is local businesses being unfairly burdened by overzealous enforcers who are more motivated by profit than quality of life. There, I said it. This hearing will examine DEP's and OATH's roles in enforcing the noise code to balance the needs of all New Yorkers. In addition, we'll hear several bills that will make civilian enforcement of the noise code less financially lucrative and more objective, make it easier for New Yorkers to request and obtain the results of certain noise inspections, and reduce the overall level of unnecessary noise in the city. These bills include Intro 1194, which I sponsored, or am sponsoring, that would cap the compensation civilian enforcers can receive when their complaint prompts proceedings under subdivision B of section 24-244 of the noise code at $5 for proceedings brought by DEP and $10 for proceedings an enforcer brings themselves. This would reduce the financial incentive for, well, let me just kind of edit this sentence as I read it. This would reduce the financial incentive for individuals who file multiple harassing complaints against businesses for the purposes of collecting the award money, and will allow DEP inspectors to focus on legitimate noise complaints and on improving the quality of life for all New Yorkers. We will also hear Intro 160, sponsored by Councilmember Holden, who would amend the definition for, quote, unreasonable noise, close quote, as applies to commercial establishment to be sound that exceeds specified prohibited noise levels. Unreasonable noise would include impulsive sound above 15 decibels measured at any point within the property in question, or 15 feet or more from the source of the sound on the public right-of-way. I just have a sidebar on that. 20 years ago, when the mayor did his revamp of the noise code, and it came before this committee, and I was chair at the time, it was my understanding that we had put that all to rest, and that there was a big, this is a little history, there was a big fight at the time about the Bloomberg administration's desire to have an unreasonable noise standard for business establishments, for people having backyard parties, for people doing loud noise in their apartments or whatever. And I and the council, the council at the time, the committee at the time, thought it was unfair for businesses to not have an objective standard that they had to meet. Just like one drives a car and the speed limit is 30, you know the speed limit is 30. And so we felt it was important to have an objective standard that, that business establishments could be apprised of, and they would have to stay within that standard. That would be measured by a decibel meter, because if the Bloomberg administration had had its way and it was an unreasonable noise standard that applied to business establishments, any business would be subject to a violation for noise for anything, depending upon the individual writing the summons. And so how can a business reasonably prepare and how can they operate if they have no idea when they're going to be violated? And so, be served with a violation. So that was when we came up with the noise meter for establishments. That was going to be their standard. They'd be apprised of what the decibel standard is, and they would have to meet that. They would know it. They can get an engineer. They can look at it. They can measure it. And then they'd be in compliance. And if someone caught them being out of compliance, as measured by a noise meter, they would get a violation. And the unreasonable noise standard, this is back 20 years ago, and we thought we'd put all this to rest. The unreasonable noise standard was still going to apply for things that were not establishments. For someone having a loud backyard party, someone playing loud noise in their apartment at 3 in the morning. So there was certainly is a road for an unreasonable noise standard. And so, but it seems, I'm not a lawyer, but it seems that there is still ambiguity as to what that, what we actually did 20 years ago. And I think the Holden bill speaks to that. And so we will hear more about that, but I just thought that history lesson was in order. We fought like anything to get the noise standard measured by a decibel meter. To be fair, there was bloodshed over that provision. But we prevailed, and now it seems that unreasonable noise standard for businesses. I understand the difference between noise emanating from the operation of business and people pointing speakers out to say, come and shop here, buy a necktie here. I think that's a little bit of a different story. But certainly, so the plot thickened over the last 20 years to where we are now. And so, where was I? Where were we? 774? Is that where we are? Okay, we'll hear a package of bills sponsored by Councilmember Powers that includes, look at this package, look at this whole thing he's got here. Intro 774, which would require DEP to measure the volume of certain types of construction noise from within dwelling units upon request of the owner, lessor, or occupant. Intro 775, which would mandate that DEP publish the results of their noise inspection online within 24 hours after they have been completed. Intro 776, which would require DEP and NYPD to give a copy of a noise report pursuant to a 311 noise complaint to anyone who requests the report and provides the 311 tracking number within 14 days of the request. And the majority leader is going to speak on these bills in a minute. I just kind of want to set them up. Intro 777, which would require any person engaging in a construction project to obtain an after-hours variance before removing construction debris before or after certain hours and on the weekend. And Intro 778. He's the majority leader, so notice that all of his bills are in consecutive order. 774, 775. You got to be the majority leader to pull that off. Intro 778, which would establish a noise camera program to detect motor vehicles in violation of the noise code. Vehicles found to be in violation are subject to the civil penalty as prescribed by existing law. The bill would require DEP to report on noise camera on the noise camera program annually. Finally, I would like to thank the really terrific committee staff who have done such great work over the years, particularly on this hearing. Committee counsel Samara Swanson and Clara McLaughlin, policy analyst Ricky Chawla and Andrew Bourne, financial analyst Andrew Lane Lawless, and finally my great legislative director Nabi Kaur for all of their hard work. Before I turn it over to members who have bills for statements, I want to recognize that we're joined by Councilmember Holden, who I made reference to, Councilmember Nurse, Councilmember Menon, Councilmember Majority Leader Powers. We have Councilmember Hanks on Zoom, is that correct? And is Lincoln here on Zoom? Okay, Lincoln, and Lincoln Ressler, who when he asks questions will no doubt go over time, but I always indulge him. And I think I got it. And with that, Bob, you're a member of the committee, and but if you wouldn't mind, we do have the majority leader with us. If you would defer and have me call upon the majority leader to speak about his package of bills first, is that okay, Bob?
Yeah, that'd be great.
Okay. Councilmember Holden is being most gracious, and now I recognize the majority leader to speak on his good bills.
Thank you, Chair, and thank you to Councilmember Holden, who I know has a bill that we're hearing here today. I also want to congratulate Lincoln on achieving the Donna and Cher status as one name per people in this world. But I really want to thank the chair and the staff here for giving me the opportunity to hear these bills today and being great partners on a number of issues that we're working on together around environment and quality of life. We introduced a package a few months back we called the Stop Spreading the Noise Act. Yes, it's a bad pun, but you're going to have to deal with it, my friends. It's to help to reduce excessive noise across the 5 boroughs. This is directly from constituent calls that we get every single day. And whether you are in Manhattan or anywhere else in the city, I can tell you without question, your neighbors and your constituents are dealing with noisy issues every single day. We all know New York is a city that never sleeps, but between noisy helicopters, constant construction, and loud cars, I think we all can agree it's time for some quiet. I've introduced these 5 bills to help tackle some of the most common and frequent issues that we hear in my office. First, Introduction 778 establishes a noise camera program to help us detect noisy vehicles and issue violations to any drivers found to be violating city noise limits. This bill would require annual reporting on the locations of the cameras, the number of violations detected, and any revenue raised by the program. And I want to note that the DEP, as I understand it, is rolling out a program right now to evaluate this and to understand how it could work here in the city. We also know that construction is another major source of noise. Intro 774 will allow New Yorkers who live near construction sites to request an inspection of sound levels within their home through DEP, and to cut down on construction-related noise overnight on weekends. Intro 777 would require an after-hours variance for the removal of construction debris, 2 things that we've gotten calls about in my office. Introduction 775 and 776 will help our 311 noise complaint system to be more transparent and effective by ensuring the results of those noise inspections are published online within 24 hours and made available to anyone with a 311 tracking number. Like a lot of issues of 311, it's a fantastic system, but we often hear New Yorkers complain about what happened to that actual call I made. And we think that on this particular issue, they deserve a right to have the outcome of that call in their hands to understand better how that city and that system's working for them. And to be clear, noise is not only a nuisance, it's a public health issue. The Department of Health has reported that 1 in 6 New Yorkers already experience ringing in their ears or hearing loss, and 20% are frequently disturbed by noise at home. Long-term exposure can not only lead to hearing loss or stress and sleep disruption, but also high blood pressure and heart disease. It's also, we're obviously coming off a period of time where many New Yorkers are staying at home and working, or working increasingly at home, and we have seen citywide the amount of complaints go up, enforcement go down, or the ability to respond to those perhaps stay even, while we try to tackle many more complaints coming in. And certainly for the New Yorkers who are experiencing a new way of life, they deserve an opportunity to have a greater opportunity for peace and quiet. I'm confident this package of legislation will help greatly to improve the New Yorkers' quality of life. I want to again thank Chair Gennaro for holding this hearing, the committee staff for their work. I want to thank you, my staff, for helping to put this package together. I look forward to hearing the testimony today and moving forward this package of legislation to make New York just a little bit quieter. Thanks so much.
Thank you very much, Mr. Majority Leader. It's my privilege to recognize my colleague and great member of this committee, Councilmember Bob Holden, to speak on his bill.
Thank you, Chair Gennaro. And to just follow up on Majority Leader Keith Powers' comments, the noise problem in New York City has been forever. We all know this. And particularly if you live in a mixed-use area, commercial along with residential. And so there's got to be a balance there. And so the introduction of my bill, Intro 160, is a big step in addressing a significant problem we face in New York City. Of course, the noise. I'm not a big fan of noise, and some of my legislation in the past has shown that. And I know many others feel the same way. Noise pollution can really impact our daily lives and our quality of life. With my bill, we're looking to take action to deal with this issue seriously. We're setting clear noise standards that don't leave room for any compromise. Many times it's very subjective. You get a police officer, and if you call it into 311, it tells you on 311, it'll take 8 hours many times to address it, within 8 hours. The problem we have, and my district is certainly one of them, we have a problem where the officer goes there and says, oh, it's not that noisy. And then the homeowner calls and says, listen to this, councilman. Look how noisy this is. I have this for 8 hours a day. So we need some kind of standards. So I'm hopeful that these measures will make our city a quieter and more comfortable place to live, again, particularly in mixed-use areas. So I'm looking forward to hearing from both the administration and the public on this matter. I'm open to suggestions on the bill. If people feel that it's too strict, we could change it. We can modify it. So your feedback and support are crucial as we work together to create a more peaceful and enjoyable urban environment in New York City. I want to thank the chair again, but I also want to bring up a little history, if you don't mind, Chair Gennaro, that Mayor Bloomberg tried this.
Please do so.
Mayor Bloomberg had Operation Silent Night. Does anybody remember Operation Silent Night? One person in the room. And where'd it go? It went nowhere. Nothing really came of it. It's a noisier city. So I thank the chair for this the series of bill and the majority leader, because these are important bills to improve our quality of life. Again, thank you, Chair.
Thank you. And notwithstanding the fact that Silent Night didn't turn out the way a lot of people thought, when the mayor put forward his comprehensive overhaul of the noise code, which he put it forward, I think, in 2003. By the time we got through with all the yelling and screaming, it was like 2005 when we actually got it done. So it was, it affected the karting industry, it affected building managers that had air circulation devices, it affected construction, karting. It was a comprehensive package that I thought did a good job, but not everything is a big hit. So Silent Night wasn't a big hit, but to the mayor's credit, he really tried to take noise seriously. We got a lot done, but we're back, and with that, I think we're ready to call the first panel, the Office of Administrative Hearing and Tribunals. I'd ask the committee counsel to swear in the witnesses, and I'll just, as a matter of, just a statement, I want to thank DEP for, kind of working with us to structure the hearing this way. Ordinarily, this is when we call the administration this hearing, ordinarily it would be DEP, would be the first entity to testify. But as always, we work well with DEP, we work well with the administration, and I worked well with Oath before. I was the one that gave you folks the ECB. I don't know if you enjoy that or not, but it used to be in DEP. We took it out of DEP and gave it to you. And I hope that worked out for you. And so with that said, let me make sure I have my copy of your testimony in front of me. And the witnesses are sworn, right? Have they been sworn or just called forward? Have they been sworn yet?
Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
Thank you very much. I have your statement. You may proceed with your testimony.
Thank you, Councilmember, Chair Gennaro. Thank you. Good afternoon, council members. My name is John Castelli, and I am the Deputy Commissioner for Legislative Affairs at the New York City Office of Administrative Trials and Hearings. I would like to start by thanking Chair Gennaro and the members of the committee here today, taking the time that I know you have extensive responsibilities, and it's appreciated. I'm joined by my colleague, Amy Slifka, who is the Deputy Commissioner of our Hearings Division. By way of background, Oath is New York City's central independent administrative law tribunal, and our mission is to ensure that everyone who appears before us receives a fair opportunity to be heard and a timely resolution of their case. We are a high-volume court, and in fiscal 2023 alone, in our Hearings Division, we processed almost 765,000 summonses and held over 238,000 hearings and issued close to 2,000 appeals decisions. We also closed after trial or by settlement conference approximately 4,200 cases at our Trials Division. In each of these cases, we take great care to ensure that every party who appears before us is treated impartially and is accorded due process. In order to fulfill our mission, ensure impartiality, and protect due process, Oath must remain independent from the many city agencies that appear before us. New Yorkers, including individuals, homeowners, and small businesses, need to know that when they come before Oath, they are coming to a place that is unaffiliated with the agency that issued them a summons or notice of violation, and that they will be given a fair hearing. I have had the opportunity to do outreach events in a number of council districts, including some of your own. And if I haven't done it with you yet, believe me, I'm going to be there at some point and looking forward to it. And through that work, I've come to learn that your constituents rely on Oath being independent. And for these reasons, we take our independence very seriously. One way that Oath maintains its independence is by not getting involved in enforcement matters. Oath does not opine on potential enforcement legislation, enforcement policy, or enforcement penalties. Those decisions are for the policymakers. We are the tribunal. Once a law is passed, we apply that law to the facts of each case brought before us. Consistent with this, Oath takes no position on the package of proposed legislation that is under consideration at today's hearing. We are here today because we understand that the committee has questions about Oath processes and data, and we are happy to assist the committee in understanding how Oath works, and we will do our best to respond to your questions. Thank you, Chair Gennaro.
Thank you very much for appearing here today. We appreciate all that Oath does. We're also joined by Councilmember Gutierrez. She has joined us. We're grateful to have her. And you came out to my district recently, and we have to coordinate that. Yeah.
Yes, Chair. We had a tremendously successful event out in your Kew Gardens branch library, and we're looking forward to coming out again.
Yeah, there was a little disconnect with my office, but but we certainly appreciate getting out to Queens, particularly my district. Okay, I have some prepared questions, but just help me out here a little bit. So on August 17th, there was a resolution put forward by Oath regarding the exercise of authority to remit a civil penalty in code section 24-244B matters. This has become a big deal. And so if you could just, for those that are not familiar, because this seems like kind of an extraordinary thing for oath to put forward, because it wasn't in relation to one specific appeal or whatever. It was just oath putting this out, and if you could just walk us through the reason why oath felt compelled to put out this resolution. This is a real resolution with whereas clauses and a resolve clause and all the trimmings. What compelled oath to do that? And for the lay people here, what are you trying to get across to folks?
Mr. Chair, the decisions made by the Environmental Control Board are something I can't comment to as a representative of the Administrative Law Tribunal. Those decisions are, they speak for themselves, just like the decisions that are made by the quasi-judicial decisions that are made by our hearing officers and our ALJs, so I can't speak to that decision.
All right. I am officially 0 for 1 now. Let's see if I can get my batting average up. Lincoln's, one of his jobs is to chuckle at things that I say, if nothing else. You're supposed to do it all the time. Okay, thank you. Now, in light of what you said, let me ask questions that would be appropriate for oath according to how you just couched that. This could be, I just want to get this on the record, you probably have to get back to me with this. What is the total monetary value of the civil penalties that oath has sustained for citizen-initiated summonses alleging a violation of section 24-244B?
That I'd have to get back to you on.
Yeah. So again, this is things that we want, and so we appreciate that. What percentage? You may have some sense of this, you may not, or may want to get back with the precise number. What percentage of citizen-initiated summonses alleging a violation of section 24-244B have been defaulted on?
The percentage is 59%.
So 59% default, okay. All right. Now, the citizen enforcers have been using section 24-244B, which I believe is really meant for those that have speakers facing out from an establishment trying to generate business. Are you in a position to tell us whether or not that section of the code is being applied correctly when it comes to businesses that are not have outward-facing speakers, but they have ambient noise within the establishment that spills out into the street? That is my understanding. It was supposed to be like a decibel noise measure standard and not subject to the unreasonable noise standard.
Mr. Chair, we wouldn't be able to comment on whether or not the enforcement, this is more of an enforcement type question. We can comment on the processes where we have a citizen prosecuted summons filed with oath, and we can tell you what happens once that summons is filed. And I do want to stress that I have tremendous respect for this committee and the council, and I don't like to tell you, hey, I can't.
No, no, it's fine.
So I just want you to be aware of that.
John, don't worry about it. We feel you. We get it. Yeah, you know. But I will, for the sake of the public, indicate just to put on the record that this, August 17th there's this August 17th resolution, talks a lot about 24244B, and what it really gets at is that, I'll just read the resolve court, that the board exercises, meaning the Environmental Control Board, exercises the authority granted under 2425 Section B, well, that's the whole, civilian enforcement thing, to remit in whole the civil penalty in all matters wherein the summonses charges a violation of 24-244B upon finding at the hearing that the respondent is no longer in violation. Accordingly, upon a hearing officer so finding, a zero penalty shall be imposed. And I just want to let that sink in a little bit. So this is from the board saying that if someone brings something forward under 24-244B, if the respondent is no longer in violation and that can be substantiated, a zero penalty shall be imposed. Seems to me, this is my own editorializing, I'll own it, that the oath has kind of had it with these violations, and this is their own way. My interpretation, that this is their way of like putting forward that what's been going on since this fairly recent phenomenon of the citizen enforcers going out and using 2444B in a way that differs from what it was intended. To me, this is oath doing kind of all it can to indicate that as long as the condition is now corrected, no penalty would be imposed. And so I know that oath is kind of in a little box here and has limited ability to opine on this and that. But to me, this was a striking resolution. I think kind of an act of courage on the part of oath, and I salute you for that. That's not a question; it's a statement. But getting back to that 59% number. So someone gets a violation under 24244B, and maybe that section of the code is being applied in the right way, maybe it's being applied in the wrong way. But if they default, they lose, judgment against them, they have to pay. The citizen enforcers, get their bounty or whatever you want to call it. And then the businesses have to pay. So this is a 59% default rate, so that I think is, are there, just to turn this into a question, I mean, is it ordinary for a lot of different violations for there to be like this level of default, or is 24-244B, unique in its, percentage of defaults?
I couldn't answer that question regarding.
It was a good question, though, I think.
As the Administrative Law Tribunal, our role is to ensure that the hearings happen. I can't speak to or can't opine on why someone defaults, fails to answer a summons. And I can't.
Well, I tell you what, why don't we have someone from Oath, if you wouldn't mind, put some numbers together on default rates. If that's, obviously it's public information. I just want to kind of zero in on that 59% default number.
I can look into that, and we'll get back to you.
Okay,
see what we find.
sure. And regarding the Oath Appeals Unit, if you're able, can you describe the role of the Oath Appeals Unit, and are the decisions of the Appeals Unit binding on all hearing officers?
The decisions by the, depending on, obviously there could be factual distinctions between cases, but where the facts are basically the same, a decision is made with it when it's those facts are applied to the law in question. If the appeals decision is made based on those facts and there are similar cases, those similar cases could follow that decision. Again, but each case is taken on its own.
Right.
So there are so many nuances involved, as you know.
Yeah.
Regarding yes, and my answer is it depends, basically.
Right, but so when something is appealed and the appeals unit comes forward with a decision that is that's what lawyers might call precedent or something. Is that a proper use of that term, counsel? But it is so these appeals would be disseminated to the hearing officers, and they'd be aware of various appeals that when they're in the midst of adjudicating, whatever they're adjudicating, it would be fair to say that would be guidance for them, right?
Pursuant to the charter requirement, yes.
Right, okay. And has oath seen an increase in citizen-initiated summonses under 24261 alleging a violation of section 24244B in the last year? Do you have any sense of that?
I couldn't tell you. I have to get back to you on that.
All right. There's so many questions here. I want to be, and ordinarily when I normally bring in my other members fairly early to ask questions because I like to get them involved and engaged. I'm being a little bit of a ball hog here, and it's not my way to do this, but this is kind of a special case. Pardon me while I shuffle through papers. Well, I kind of get my head together for my next question. We have Councilmember Nurse, who has asked for the opportunity to ask questions. I recognize Councilmember Nurse.
Chair, I think my question is going to be for DEP.
Oh, no, these would just be for oath, okay. And so.
Yeah, mine will be for later.
What's that?
I have a question for later.
Okay, fine, sure.
Okay, thank you, Chair.
Yeah, so, yeah, when DEP's on, we'll do that. Okay, I recognize Councilmember Holden for questions.
Thank you, Chair. Just a few questions on the types of complaints and some of the defense that we hear from, let's say, some establishments. And I'm more interested in hearing from commercial establishments. Like, do some of these commercial establishments say, or do most of the defense would say, I didn't know about the law, or I didn't know the standards of the law?
I mean, in that scenario, the answer would be yes.
That would be the majority of the time.
I couldn't tell you.
They didn't know they were violating the law.
Again,
And essentially noise complaints. I would think that would be probably the defense.
That could be a defense, yeah.
So when you say that there was a default, that means they didn't answer the complaint?
They failed to answer the summons, which
failed-
means, yes. I'm sorry, Councilman.
And then, so tell us what happens.
So if they fail to answer a summons, what happens is oath will notify the respondent, business establishment, and let them immediately notify them and let them know that you've missed your hearing. Please contact us ASAP regarding this. And they get 75 days from the date of the hearing that they missed where they can file a motion to vacate that default. So that's 75 days without any questions asked. They will be given, once they file that motion to vacate, they could do it online, they could do it in writing, they will be granted a new hearing date.
So you automatically give them a second chance?
Second chance, yes.
respond.
Yes.
And then what happens after that if they don't?
Well, if they don't, then if it's more than 75 days and less than 1 year, they need a reasonable excuse to get a motion to vacate that default. They have to provide a reasonable excuse. And if it's more than a year, they're going to need a extraordinary circumstance to succeed in getting that motion to vacate.
All right, at what point do you generate a summons?
Well, we don't generate
You
the
don't generate,
summons.
but the
summons,
agency will.
the summons is filed with us by the enforcement agency. That's when it comes into our universe. That's when it exists in our
Right.
world. So it depends when the agencies file it with us.
So it's up to them if they file.
Yes, and they set the hearing dates.
All right, thank you, Chair.
Thank you. Thank you, Councilmember Holden. Now, most times, the entities that bring summonses forward to oath would be agencies. You have,
Yes.
And are there any special accommodations or changes to oath's practices that must be made for citizen-initiated summonses as opposed to when the petitioner is an agency? How does that work?
Well, obviously when the agency files a summons with oath, then it comes into, again, as I said, the adjudicatory process begins, and then there is a hearing, and until we get to that hearing, there are no ex parte communications between oath and any of the parties. The only time we have any communications is on the record at the hearing. Now, when a citizen prosecuted summons is filed with oath, then it's treated, the hearing date is set similarly to the enforcement agency sets the hearing date, and also the citizen complainant, citizen prosecutor who prosecutes the case. They have to appear at the hearing. Now, sometimes the enforcement agency does not appear. They don't always appear at the hearing. They usually do. But in the case of the citizen...
Okay, just hold on that point again. So you got a citizen-initiated adjudication that's going on.
Right.
So the entities that would be there would be the adjudicatory entity, which is you folks.
Yes.
And then you have the person making the complaint.
Yes.
You have the person that the complaint is being made against.
Yes.
And then you would have the agency that's involved.
No. What I'm talking about is where it's a citizen prosecuted summons that's filed with oath. It's the citizen complainant who has to appear at the hearing to prosecute the case against the respondent before the oath hearing officer.
Right. And let's just say this citizen enforcer makes an allegation of a violation, and oath makes a determination that the section of the code cited by the complainant is not the right section of the code, or that section of the code doesn't apply to the complaint that they're bringing forward. what happens then?
I'm going to defer to Deputy Commissioner Amy Slifka, who's the head of our hearings division.
Right.
You give a better answer than me.
Sure.
So basically, from what I'm
Please
hearing...
state your name for the record.
Oh, I'm sorry, Amy Slifka, Deputy Commissioner of Adjudications at Oath. So basically, from what I'm hearing you're saying is if a summons is issued, and for example, the facts don't make out the charge for the section of law, if both parties are present, then the hearing officer would hear the case, petitioner would present their case, in this case a citizen complainant, the respondent would present their case, and the hearing officer would decide make a decision on the case. If the facts don't make out a case for the section of law charged, then obviously it's not making a prima facie case, and it would more than likely be dismissed. But this is not done ex parte, this is not done by the hearing officer without both sides being given an opportunity to present their side of the case.
Right, but the individual who would actually be doing the adjudication would be a hearing officer and
Correct.
ALJ or
It's a judicial hearing officer. It's a
Right.
hearing officer. Right.
and so that person is obliged to make sure that the code is that
Applied
the section is being applied correctly.
Correct.
Okay, and that's that, right?
And that's that.
Okay, all right. Okay. I recognize Councilmember Nurse, who has a question for oath.
Just one question. I'm just trying to understand what data you can share. I had a question about how many of the complaints that have been initiated by the two people who I'm reading make about 90% of the noise complaints. How many of those are successful?
Thank you, Councilmember, for the question. First thing I just want to clarify so I answer the best I can your question is, when we, at Oath, we look at citizen prosecuted summonses and they're not citizen complaints. So they're filed with us, the citizen prosecuted summonses. That's when, so in
So
terms
of those that are filed with you,
I couldn't tell you what the numbers are. I could not tell you. I can check.
what kind of
see if I
data
can
are
find
you
out.
able to provide today? I mean, related to this hearing. I'm just kind of struggling to understand what we're getting here.
I'm sorry.
I'm asking, what kind of data are you able to provide today around this hearing topic?
Well, the data that was provided from the questions
The
that were,
59% one. That's
Those-
the only data point I heard, but I might have misheard.
I can't. I mean, the questions that were previously provided to us, we had given information regarding the summonses that were issued by the enforcement agency DEP and by the citizen prosecuted citizen complainants who prosecute summonses with us.
Okay. So even if you've said it or not, just to restate it, because I'm trying to keep on top of what's being said across here.
And Councilmember, please, we want to make sure
Yeah, I know. I'm trying to
we explain,
understand the
and
scale of
as
it.
the Administrative Law Tribunal, it's our job to make sure that you know, the more you know, the better it is for your constituents, better it is for all of us, and we can make sure that people get fair and impartial hearings.
I believe you. I believe you 100%.
I sound like a broken record when I say it, because that's all I say, and people get annoyed because all they hear about from us is fair and impartial hearings and due process, because that's what we focus on.
It's just been hard for me to follow exactly the numbers in this conversation. So I'm trying to get a sense of how many cases that are complaints that move into your jurisdiction where you are taking action around noise complaints have been successful.
Well, if you
How
look,
many of those cases are you getting a year? Because you testified a lot of numbers just in terms of all of the cases, but I don't know if that was
if I'm correctly interpreting the question, and forgive me if I'm not, please. What we have, the numbers that were provided, have the cases that are dismissed and the percentage. If you look at citizen issued summonses by percentage for noise, you'll see the percentage of summonses that are dismissed. That would be on page 3, if we have the same type of.
I think maybe mine has missing pages. I have a paragraph where you have, 765,000 summonses, 2,000 appeals.
Well,
I just don't know if that's like your whole
Right.
casework.
We provided numbers, and I have numbers. We provided
Okay.
answers to questions that council to the committee
Got it.
had
I will
submitted
follow
to
up and
us.
get those then, because
So,
this was not, I was like,
but-
I'm not understanding.
please feel free to.
Yeah.
We're always available. You can feel free. We'll give you our card. I'll give you my card when we're done here, so you have access. And please contact us anytime.
Okay, that sounds great. Thank you, Chair.
Thank you.
Thank you, Councilmember Nurse. Here's just one sort of final question. Getting back to the resolution, I'm kind of still stuck on that, and council, the committee thinks it's a good idea to get this question in full on the record. Again, going back to the resolution. On August 17th, the ECB adopted a resolution to exercise the authority. The noise code grants them, ECB, to remit a civil penalty upon a finding and a hearing that the respondent is no longer in violation of Section 24-244B, which concerns the use of a noise reproduction device by a commercial enterprise for advertising purposes. What factors will the ECB rely on to make a determination in each matter that there is no longer a violation?
Again, Chair, I cannot opine on the decision, a quasi-judicial decision that the board made.
Okay, but I think the resolution, does kind of speak for itself somewhat on that. And does anybody have any more questions for oath? No? Okay. With that, I'd like to thank you both for coming before us. Do you have another statement you want to make?
Just want to thank you, Chair Gennaro. Oath wouldn't be where it is today without the work that you did 20 years ago. You've helped us, you've expanded and provided accessibility, greater access to justice for people throughout our city for the work that you've done.
Well, I was getting a lot of complaints back in the day from vendors, from this, from that.
Well,
And
today-
also, we've got DEP, who is, an entity within DEP is hearing like fire violations and noise violations and all kinds of different, sanitation violations, and, the ECB of that era didn't have like such a great reputation. I thought it was a good idea to, to put it into oath where, oath has got some game. So I thought that would be a better place. There would just be better justice meted out, and people would go to ECB, and then they'd have to come back another day, and, I used to get a lot of complaints. And I was, again, chair of the committee at that time, and then I, overseeing DEP, and I'm like, we should move this to oath. So I'm glad for all the work that you've done, and vendors and other people that used to get jammed up at, ECB, let's just say I don't get complaints anymore. And so that is a testament to your good, stewardship of the ECB, and, adjudicating all this stuff is not really what DEP is all about. That's what you're about. So that's where that came from. And so thank you for coming before us. And now we have the face of oath at our committee, and this is your first time before this committee, so pick up your door prize before, we don't really have door prizes here.
Thank you, Chair, and thank you, members of the committee.
Lincoln is
Thanks
just
so
going
much.
like this.
I'm going to give you my card, council member.
Okay, thank you very much. We want to call DEP forward. I'd ask DEP to get themselves situated and sworn. I'll be back in 2 minutes to hear their statement.
go get a cup of tea. I'll be right back.
Okay, it is always a pleasure to have DEP with us, and you know, folks I go back with a long way. Deputy Commissioner Licata, Mr. Page. Well, you'll have your. I just want to call everybody by the right title, but hello, hello. Great to have you here. I look forward to hearing your good testimony. Everyone's all duly sworn and everything? Okay, all right. With that, oh, they haven't been sworn in? Okay.
No.
The council could swear in the witnesses.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee, and to respond honestly to council member questions?
I do.
Okay. Thank you very much. Again, a pleasure. Please, please commence with your good testimony.
Well, good afternoon, Chairman Gennaro and members of the Environmental Protection Committee. We would like to begin just by introducing my colleagues. As you noted, this is Mark Page. He's the Executive Director of the Bureau of Environmental Compliance, and sitting to his left is Alyssa Preston. And yes, I knew you would recognize that name.
Have you been in DP all these years? Oh, it's been a long time. So good to see you. So good to see you.
She's the Director of Air Noise Policy and Enforcement. So, I am Angela Licata, and I'm Deputy Commissioner for the Department of Environmental Protection, and thank you for the opportunity to testify today. I'd like to begin with a brief overview of DEP's noise enforcement work, including the Citizen Complaint Program, and then we'll speak to each of the bills being considered today. To begin, DEP and my colleagues were very proud of the work that we have done to improve the quality of life for all New Yorkers by enforcing the city's noise code. The code does ensure that the city that never sleeps remains vibrant and active while meeting the needs of those who live in, work in, and visit the city by reducing noise pollution and protecting public health. DEP and the New York City Police Department share responsibility for enforcing the noise code. DEP's responsibilities focus on commercial music, construction noise, noise from buildings, heating and ventilation equipment, and DEP's noise inspectors proactively approve and inspect noise mitigation plans and respond to approximately 50,000 noise complaints each year. The noise code has been updated twice in recent years. First, as Chairman Gennaro explained, was in 2005. And then we had some updates and improvements that were made with Local Law 53 of 2018. And we are very grateful for the leadership and the support of the New York City Council, and especially of the now chair and then chair, Gennaro, for making these improvements. We are forever looking to continue to make these improvements, so we don't want to rest on our laurels, but we do want to appreciate how far that we've come since the 1970s.
Although I will indicate that Local Law 53 of 2018 was when I wasn't here. So anyone who's got a problem with that law, that ain't me, you know. And so, thank you very much. You know, it's always it's great to be partners with DEP. We've done a lot of great things together over the years, the council and DEP. Please continue. Forgive my interruption.
These critical updates standardize commercial music regulations, require these noise mitigation measures for construction activities, created a section that prohibits excessive noise from motor vehicles. Since the 2018 changes, DEP has been required to respond to after-hours noise complaints in specific timeframes, and requires that all noise mitigation plans be filed electronically and be available for public inspection. These changes have significantly strengthened DEP's enforcement. In addition to the proactive enforcement, DEP inspectors focus in areas of known complaints, and they also have very specific training and can use their discretion to determine if there is a violation or not. If an inspector determines a complaint is justified under the noise code, the inspector informs the business of the alleged violation and what can be done to correct it. And that is generally before a violation is issued. Depending on the severity of the alleged violation and whether or not it is purposely and egregiously performed, these are the levels of discretion that our inspectors are trained to provide. And our goal, again, I need to be really clear, is to bring businesses into compliance with the noise code and to reduce noise pollution for the benefit of the public and its public health. The goal is not to be punitive. The goal is not to make profits. Although, as we stated, we do not hesitate to issue summonses to bad actors.
Angela, I'm going to confess that I've lost my place.
We're going to start with a paragraph. Of course, DEP's inspectors will never be able to address all of the city's noise issues as they are happening.
This page 2?
Mm-hmm.
Top.
Of course, DEP's inspectors will never be able to address all of the city's noise issues as they are happening.
Keith, you got this? Not the one with the map. Is my thing put together wrong?
Don't use that one, sir. I think that one would have been missing a page.
Oh, my testimony is missing a page.
Yes.
I'm vindicated. Okay. We should have music in the background as we kind of figure this out.
Give me a second, sir.
Okay.
Beginning with the paragraph, of course.
I don't have anything in front of me now. I will soon.
The testimony that was given to us, I think, was missing some pages. So,
Yeah.
at least on some of the legislation, it was missing some of the bills.
Yes. There was a missing page. Now I have the page. There's a partial paragraph, and the first whole paragraph begins, of course, DEP's inspectors, right?
Correct.
Okay. Sorry for the hubbub.
Okay. So it says, of course, DEP's inspectors will never be able to address all of the city's noise issues as they are happening. We simply cannot be everywhere all the time. This is why citizen enforcement can be a useful complement to DEP's work. Local laws allow us to allows anyone to provide evidence of potential violations of certain sections of the noise code to DEP. DEP or the reporter can then bring this evidence to the Office of Administrative Trials and Hearings for a hearing to determine whether a violation has taken place. We believe citizen enforcement is valuable, but it needs to be fair. Citizen enforcement of the noise code should pursue the same goal as DEP-led enforcement, encouraging compliance and reducing noise pollution. Unfortunately, that has not been the case
You know what,
recently.
if I could just jump in again, sometimes, if I don't do it now, and please pardon the back and forth. And so, with regard to the citizen enforcement, you talk about here's how it works. Local law allows anyone to provide evidence, potential violation of, and so DEP or the reporter can then bring this evidence to oath for a hearing. But don't they have to bring it to DEP first?
They come to DEP first. DEP has 30 days to either seek enforcement on its own in conjunction with the citizen, or
somebody comes to DEP and they have a complaint, and so DEP can send their own enforcement people out there to monitor it, do what needs to be done, assess it, issue violations or whatever. So DEP gets that. And failing that, like, what happens? So DEP decides for whatever reason. So if somebody brings a complaint and DEP wouldn't go out there if it's just like something that already happened, and somebody comes forward and they have evidence or whatever, right? Then DEP like takes a look at that. And then DEP can use that evidence to issue its own violation.
yes, DEP can issue its own violation if it witnesses. It can go out there, as you stated, and look.
No, but can they do it based on
the citizens?
Based on the citizens' information that's been
Yes.
brought forward. It could be a videotape, it could be an audio tape, it could be a decibel level reading, it could be whatever the heck it is,
Yes.
right? And so based on that, DEP can issue a violation, and then DEP is the complainant, and then it has to go and deal with oath.
Yes, DEP would co-sponsor that complaint. The citizen would get a portion of that penalty if the penalty is upheld at oath. So they would receive some of that penalty money.
Right. Okay. All right, this is, I don't want to get too much into the question, but just know that coming out of this, Alyssa, there's going to be a question about this section, whatever it is, whether or not section 24-244B, people using that section for sound reproduction devices, which I believe, and you correct me if I'm wrong, is really meant for people that are using that for advertising purposes. But yet these violations are being brought to DEP for ambient noise that is spilling out into the street, therefore not. So I just think that's, the wrong section of the code. So just get ready for a question on that, and why DEP is even entertaining these and not just indicating like you got the wrong section of the code, go home. And so, so that question is coming. Okay. Make sure I do that, okay? Fine. Please continue. I'll try to limit my jumping in.
Unfortunately, that has not been the case recently. Citizen noise enforcement has been a significant problem for many businesses this year, with businesses receiving multiple violations by citizen enforcers all at once without a warning and racking up thousands of dollars in fines for minor infractions. We do not think this has been fair, and we thank the chair for his attention to this real issue and to protecting the livelihood of businesses unfairly targeted by a select few citizen enforcers. Citizen enforcement is supposed to be a tool to reduce genuine noise pollution in circumstances where DEP inspectors cannot respond in real time. The program is also used for our vehicle idling program, a program that has been largely successful and that is playing an important role in improving air quality in the city and helping communities protect themselves from pollution. The idling program allows citizens to film a vehicle idling and submit the video with a description of the incident through the DEP website. DEP inspectors then review the evidence and issue a summons if warranted. If the vehicle owner is found in violation at the subsequent oath hearing, the citizen who submitted the evidence is entitled to receive 25% of the collected fine. If DEP does not issue a summons and the citizen decides to self-pursue the case with oath, then the citizen is entitled to receive 50% of the collected fine. Some citizens have realized that the money-making potential of the idling enforcement program and begun to patrol neighborhoods looking for idling vehicles. Overall, the diligence of idling enforcement has been a positive thing for communities and our air quality. However, there are some overzealous, opportunistic citizen idling enforcers who have abused the program. Some participants have been egregiously aggressive towards our staff, and some have tried to defraud the system by doing things like filing fake videos or resubmitting the same video repeatedly. Our staff has thwarted their attempts to submit falsified evidence, and they are also successful, in fact, that a few participants started looking for new ways to profit from the citizen enforcement programs. About a year ago, these few participants realized they could file noise complaints against businesses who are playing music outdoors. Because noise videos do not have time minimums, they could make money more easily. A small number of people abuse this enforcement option and have been targeting, harassing several businesses. In fact, about 90% of the approximately 6,000 noise complaints filed in 2023 by citizens were filed by only 2 people. As you can see on the map that we provided in the testimony, these citizens have been targeting specific areas of Queens and Manhattan. They are mostly commercial areas where they can walk down the street and record sound from multiple businesses in just a few minutes. Locations of citizen enforcement of Section 24244B, which relates to businesses playing music outside for commercial purposes.
Oh, I just lost my place. So you have, as you can see from this map, they can do sound from multiple businesses in a few minutes. Then you have the map, and then what happened after that? Did you skip
Locations of citizen enforcement of Section 24244B, you should see, which relates to businesses playing music outside for commercial purposes.
I don't have that on mine. Do you have that? Oh, okay, that's the fine print on top of the graphic. I'm sorry. Okay. Please.
The enforcement being done through citizen enforcement is hurting businesses and is not helping communities. Citizen enforcement is happening in areas where we do not receive 311 noise complaints. No one is complaining about noise from Times Square in the middle of the day, but more than 1,000 citizen complaint reports have been focused there. The participants are not using enforcement to achieve compliance and reduce noise pollution. They are using it for personal profit. And now we're turning to the legislation. Overall, the legislation being considered today complements DEP's work, and we generally support these bills. We do want to recommend a few specific changes to the introduced legislation and would like to postpone consideration of Intro 1194. Intro 1194.
Postpone consideration? This is the hearing.
Not postpone the hearing.
No, but I'm just saying that, but this is the...
Well, I'm going to testify about our concerns on that right now. So
Oh, fine.
it's
Okay.
Completely,
okay,
yeah.
Yeah, I thought you meant like you just didn't want to
relevant.
address
Yeah,
it at
no.
all. Okay, and I'm saying this is the hearing, you have to.
Yeah.
Okay.
So currently, if a business pays a fine from a noise summons by a citizen enforcer, the citizen enforcer can receive as much as $660. Subsequent violations have heavier fines than the first one, so enforcers are incentivized to stack a series of complaints against one business and deliver many at once. Before a business has received one summons, they already have racked up several more. Intro 1194 will reduce the payout collected by citizen noise enforcers from a percentage of that penalty to a flat rate of $5 or $10. This reduction would make it harder for bad actors to use these violations as a source of significant income. This reduced incentive could reduce the volume of summonses that businesses receive, addressing one of the challenges small businesses are facing. We share the goal of reducing this undue burden on small business, but we would like to work with the council to enact broader reforms to the citizen complaint program. DEP has been working with other agencies, including Small Business Services, on comprehensive reforms to improve the citizen enforcement program. These reforms will make the program a more effective tool to combat noise, pollution, and protect businesses from program abuse. Using penalty reduction to achieve the volume of complaints that a business receives only resolves one of the challenges that businesses are facing. Even if this bill were enacted as it is currently drafted, businesses could still receive many summonses and many summonses long after the alleged violation date. So we would like to take the time to defend, summonses at once, having to take the time to defend themselves at an adjudication hearing and having to pay a significant fine. In addition to these changes to protect businesses, we want to reform the program to protect city staff from repeated harassment and abuse that they have experienced. As I alluded to earlier, a small number of citizen enforcers have harassed staff at multiple agencies and the companies they provide evidence against. Some specific issues we have dealt with included several instances of aggressive citizen complaints attempting to access secure government office spaces looking for specific individuals, including an instance of a complainant attempting to assault a staff member. Aggressive verbal harassment targeted at specific employees, and instances the same piece of evidence being submitted with different allegations with the intent to generate multiple summons based on intentionally fraudulent evidence. I understand that some of your colleagues' staffs have received similar aggressive communications. If any council member has further questions regarding abusive behavior, please feel free to reach out to the administration for more details. We welcome continuing this conversation. The administration therefore wants to enact holistic reform legislation that would establish a fixed monetary payment for citizen enforcers, as this bill does, but would also ensure the businesses receive a summons in a timely manner and do not receive too many at once, limit citizen noise enforcement to overnight hours when these noise violations have a greater negative impact, create a cure mechanism so that businesses can work with DEP to resolve an issue, avoiding the need to appear at a hearing and eliminating any potential fine, authorizing DEP to establish clear rules for evidence required with reports, authorize the city to disqualify citizens from participating in the program if they are found to submit fraudulent evidence or exhibit abusive behavior. Further, we would like to update the type of violations that can be reported by citizens. Noise complaints through 311 about ice cream trucks playing music is one of the top 5 311 noise complaint categories. Ice cream trucks are not supposed to play music continuously while they are parked. DEP inspectors cannot regularly respond to these calls, so we want to expand citizen enforcement to include this noise. Intro 160 would amend the noise code relating to interior noise at commercial establishments so that noise that is generated inside but cannot be heard from the sidewalk is no longer treated the same as noise that is generated outside. This would include removing interior noise from citizen enforcement eligibility. We think this is a clear delineation to the citizen enforcement program, and it makes sense and makes the code more understandable for businesses, so we support this bill. Intro.
Okay, so I just want to jump in for a second. Mm-hmm. And so, you know what? Let me just kind of save that. Let me just mark that and save that for a question. And that's an alarm going off saying I have to take some eye medication. So as soon as you finish your statement, I'm going to do that. It's going to go off again in a minute to remind me, but Yeah, it's a thing. Okay, again, forgive the interruption, please continue. Intro 774.
Intro 774 would require DEP to measure construction-related sound levels inside homes whenever asked to. DEP follows this practice currently, so we support this requirements and is already codified in 24223D for after-hours work. DEP recommends amending sections 228 and 229 to allow for readings to be taken from a dwelling during the day with limits warranting a summons set to an increment of 10 decibels above the ambient during the day instead of a limit of 85 decibels at the A-weighted scale, and retain the 7 dBA standard or decibels at the A-weighted scale for after-hours work. Intro 775 would require DEP to post the results of all noise inspections online within 24 hours of the inspection being completed. We request that this bill be amended to extend the time window. Each inspection report must be reviewed and approved by a supervisor, and there are extra considerations when we expect a summons to be issued. We prefer to delay posting information to ensure that the information is accurate. So we would like to work with the sponsor to determine a more workable timeline. Intro 776 would require DEP to provide any noise inspection report that was generated in response to a 311 call to be provided to anyone who requests the report and has the 311 tracking number. Currently, FOIL requests are required to obtain these reports. We support the goal of this bill, but would like to discuss it in more detail with the sponsor and our colleagues at the police department. Intro 777 would add debris removal to the definition of construction work that requires a variance for after-hours noise generation. DEP currently considers debris removal in noise permit requirements as removal of material as part of the construction process. DEP does include, supports the inclusion of debris removal in the definition of construction work. Intro 778 would require DEP to establish a noise camera program for motor vehicles and lays out the specifications for how a program should work and how OATH should process violations. DEP began piloting a vehicle noise camera program in 2021. After a successful pilot period, we launched the program officially in March of 2022. The program has led to more than 300 violations being issued. The use of the cameras is an effective and efficient complement to boots on the ground or field patrol enforcement efforts. We continue to learn and evolve the program, including adopting new technologies and increasing the number of camera locations. If a noise program is required by local law, we support many of the proposed requirements, including the reporting and certification requirements. However, we would like it to complement the program that we have developed over the last few years and be flexible enough to allow the program to evolve as new technologies emerge. We're happy to work with the sponsor on this legislation as well. Thank you for consideration of these matters. We look forward to engaging in thoughtful discussion with the chair and bill sponsors to work towards our shared goal of reducing noise pollution to protect the health of all New Yorkers. And we are happy to answer any questions you may have.
Thank you very much, Deputy Commissioner Licata. So we've got like a bunch of bills by the Majority Leader, and then Bob Holden and I are fighting the war on civilian enforcement, and so I'm going to yield to the Majority Leader. He has questions on his bills. Sergeant, I'm not putting the Majority Leader on a clock, and so I recognize Councilmember Powers for questions on his bills.
Thank you. I'll try to be quick anyway, out of respect for everyone here. I just wanted to answer, first of all, thank you for your testimony. Without question, happy to work with DEP to make sure that legislation we're working on is efficient and effective. And I think your recommendations make some sense, and appreciate the constructive feedback on the various different programs we're talking about here, and I'll ask some questions. I want to start just taking a step back. We were looking at some of the data around noise enforcement in the city, which helped inform us on the legislation and going into the hearing. It feels like it's a shared responsibility between DEP and NYPD right now when you call 311 and file or reach out to call the city and file a noise complaint. I don't, trying to understand what is the actual separation of duties there. How does the NYPD respond to calls? How does the DEP respond to calls? What is the current resource allocation for the DEP to noise complaints? It seems like a tremendously high amount of them are going to the PD, and they're going out and responding. Various levels of enforcement are happening. But I guess just to understand this conversation, you have to kind of understand how we're doing enforcement in the first place. So can you share with us how DEP's role is shaped in this conversation, and where handoff happens between DEP and NYPD, or how the NYPD or DEP might share responsibilities here?
Yeah, thank you very much for the question. So first and foremost, we have air and noise inspectors. They're cross-trained individuals. We have about 65 of them on board at DEP. And we are generally enforcing the sections of the code that I mentioned in my testimony, the commercial music, the HVAC systems, and we are looking at joint operations with NYPD as well. So that is something that has really been sparked by the Adams administration. We're very grateful for the support that we're getting from NYPD, and I think they're grateful for the support that they get from us. And we do conduct a lot of shared, what we call operations, whereby we're balancing the best of both features of the departments. So we have training on the noise meters. We can actually take those measurements. A lot of our violations are actually at a higher cost. So it's also a benefit to NYPD to be supported by DEP. And we have had many of these shared operations, especially during the weekends, and especially in areas where we're having very high complaints.
So just follow up to that. If I have a noisy construction site, let's say, after hours variance, or even just a noisy construction site that it feels like it's exceeding the decibel limit, I call 311. Is it DEP or NYPD who's showing up?
It would DEP.
No,
for construction noise, yes.
Okay, because that's in the bucket that you select from. So if I call 311, they are farming it out to the agency where they believe the jurisdiction lies. So
Yes.
anything outside of the ones that you named would be going to NYPD for them to respond to. If it was a noisy neighbor, a noisy party, something like that, which I do see they respond to a lot.
Yes. Generally, the 311 scripts are very precise about who is getting routed which violation. I don't have those scripts here with me, but we could provide them.
Okay. What is the average response time for your 65 inspectors?
We are generally going within a 1-week time frame. So if we have a call, let's say there's a dislodged construction plate, right? Let's say it's road work, and we could respond to that within a day or two. But let's say we're responding under our section 24-231, where a resident would like us to take a reading within their premise. That we would schedule an appointment for. So they may have called us about an activity that's happening on a Friday night, and they know that they need to schedule that appointment with us for the next Friday night, and that's why we have those timeframes that's reserved for those types of events.
I mean, unfortunately, for the person who's staying up all night, pulling their hair out because they have a noisy thing going on outside their premises, it's that next Friday will be far too long to respond to that, which I think we're trying to get into that, including providing people more information, whether it's 24 hours, 40 hours, whatever it is, of that extra report. I think we are sometimes lacking the ability to enforce in real time, which is really when the noise issues tend to happen and the need enforcement right now. I don't disagree with the NYPD being part of it, because we have precincts in all of our neighborhoods and they can respond to quickly, but of course we're pulling them off one assignment to do another when we do that. How many decibel meter machines do you have that are dedicated to construction?
And let me just go back to your earlier comment. I think that was an excellent point. We do have rapid response units in place, and the way that we can work around making the appointment, let's say, for a citizen to issue under that section of the code, that is the benefit of having various sections of the code
Right.
that can get to
about
the same
civilian,
problem.
you're talking about the benefit of having the civilian complaint program if you reform it in the way you desire to.
It's the benefit of having that unreasonable noise. So if we wanted to respond to that complaint in real time, we could get out there and we could respond to that complaint. We could respond to various sections used to get at the same purpose.
Okay.
So just want to make that. How many noise meters do we have?
All of the 65 inspectors have noise meters.
And those can read any level of noise, whether it's construction noise or it's just,
Yes.
it basically just records the sound, the decibel like level.
They're very sophisticated machines. They're calibrated regularly, and the inspectors are trained on them. They're able to evaluate decibel levels on the A scale, which is what the human ear can detect, and they also can evaluate on other octave bands, which is very important to get to some of the bass or C scales.
Okay. And you mentioned, we just go into the civilian complaint program, you mentioned something around there being no time minimums related when they record video. Can you just explain what you mean by that? When I can read you back your part of that, but there was a point when you were making, I think, recommendations about it, that with some of the videos, I believe, there were not time minimums involved in them, so it becomes a costly endeavor. I can find my underline of that, but if you recall, I'm happy to read. Here it is. It's I'll find that section. I'll come back to it. But I did want to ask another thing. You said 90% of the approximately 6,000 noise complaints filed in 2023, so this year, by citizens were filed by only 2 people. How many total people have participated in that program?
I think we have 6.
Like, what is the other 10%?
I think we have 6.
6 civilians in New York City are filing that. 2 are responsible for 90%.
The majority are filed by 6.
And 1,000 in the area around Times Square. That's my district.
Yes.
Okay. And just to understand the violations once more, a citizen enforcer can receive as much as $660. So it's capped at $660, or that's just how the percentage would play out if you add them up?
That's the first violation.
First violation,
Yeah.
okay.
And then there would be a higher penalty for the second violation, and then an even higher penalty for the third
So
violation.
what are those violations, first, second, third, amount-wise? Not the citizen complaint part of it, but to the business. We have, presumably have some business owners here who are here to go talk about this.
Yeah.
What is the fine on them?
So the first violation is, generally speaking, on the citizen issued, is $440, and then the second violation is $880, and the third violation is $1,320.
That's what the business pays, and then the civilian is taking, I think right now, 25% of that?
25% if the department participates, and 50% if the department does not participate. And then there's also even higher penalties for the first, second, and third for default penalties. So they're very steep.
Okay, got it. So we have, and I am familiar with Times Square businesses and non-Times Square businesses who have been raising concerns about this program. There was I can't find my other, I will find it. But the question I had after that is I want to talk about the noise cameras, which we have legislation to codify that program, to expand it, maybe perhaps to distribute it in an effective way. Can you just talk to us about how that program is going right now? I understand you're going through a pilot program. I've seen, I think, some feedback on how it's working so far. I think you're rolling it out more. Are you able to share us how many noise cameras there are in the city right now? I have your violation number, I think, in your testimony, but just any feedback on what the department is learning about that program as you're rolling it out?
Yeah, so we're very, very pleased with the program now. We had one camera where we were piloting. We moved it several times, so we've practiced at different locations. We have learned that we need to have a certain configuration or roadway geometry for the camera that is part of the microphone system to be very deliberate in terms of discerning which vehicle generated the noise, but we are doing so now quite successfully. We currently have 9 cameras that we've purchased, and we have 7 that have been installed.
So say those numbers one more. You have 9 purchased, 7 installed.
And 7 installed. And we've been generally issuing our violations off the 1 camera, so this should expand quite rapidly, very quickly, as these other 9 cameras come online.
And location-wise, I think I read something, Long Island Expressway, difficult to differentiate between vehicles because of the fine. But what are you learning in terms of geographic location?
We're looking throughout the 5 boroughs, and in fact, we've had a lot of recommendations from council members for where they're experiencing a lot of complaints. And really, you know, your constituents are the eyes and ears on the ground. So we do take their recommendations very seriously. In fact, I believe that based on the camera experiences that we've had so far, that they've been proven very right, because we are issuing a lot of violations, not just for the loud muffler noise, but also for unnecessary horn honking that is not related to emergency situations.
Okay. Just to be respectful of the other sponsors here on the chair, I want to stop there. We'd be happy to continue to talk with the department about my legislation, the 5 bills we have. We think there's more to do here, and expanding this enforcement around this issue is easy way to deliver some wins for New Yorkers who are pulling their hair out. And these are all, I think, informed by real life experiences. So look forward to working with you guys on that. Appreciate it.
Thank you.
Thank you, Mr. Majority Leader. One more great package of bills that you're bringing forward. I really appreciate you doing this, and very happy to give you the latitude to ask questions as long as you want. And so thank you for that. I just told Councilmember Holden that I was going to ask a question before I go to him, but I just had the thing that I was going to read from, I want some copies made of it, because I'm going to give them to DEP. And so while that's going on, I'm going to recognize Councilmember Holden for questions.
Thank you, Chair. And I just want to follow through on Majority Leader's questions on the noise camera, because they can't happen fast enough. You know, you have the mufflers that backfire, sound like gunshots. I have them every single night within earshot of my home. And the guy comes by every, you know, almost the same time. So these noise cameras, are they very expensive, first of all? I mean, there's probably different makes and models and so forth. And how expensive are they? Because that'll dictate how many we put up, I guess.
Yeah, they're running about 50,000, 35. Yeah, 35,000. They will improve.
35,000 each?
Each.
Okay. And you have 9 cameras, 7 were installed, but how come the other 2 weren't installed yet?
They're just going up now as we speak. We have staff that are employing them.
Now, so these, and I'm worried, because when I hear we don't have that many, I'm just worried that they're going to be in Manhattan and not in Queens, only because, you know, there's a bunch of bills that we have, but I think we also have to sleep in Queens too. and we chose to live in residential areas mostly, yet we have things that we've never seen before. Yeah. We have, first of all, why would somebody modify their muffler to make it sound like gunshots? We'd never had that before. We had some people that just soup up their cars, and obviously that happens. It's always happened. But now there's a strange phenomenon. People just like to make noise. And if the cameras are that successful and can generate, again, I just wanted to ask about the fines. Let's say you do get a guy with a muffler and you caught them. What's the fine?
$800.
This is why I like DEP when they're involved, because when NYPD is involved, and I just want to ask a couple of questions. I guess I'm on the clock, right? Yeah, I see.
We're partners on this whole
Okay,
civilian
so-
thing, and so I'm going to take you off the, plus I'm
but
waiting for my
no, I
stuff,
think
so
I
knock
think I
yourself
could-
out. It's
okay.
It's good.
Just a coordination between NYPD and DEP. Because I've had chronic locations where NYPD cannot handle. They just, the local precinct, and I listen to the scanner, they're busy with 911 calls. The noise complaints, when they get around to it, and it's rarely now with the new police department is it within 8 hours like they promise on 311. It's sometimes the next day, 24 hours, and of course the noise is probably gone. And so when does NYPD, are they mandated to contact DEP at one point because they can't address it? It's a chronic location.
So that's an excellent question, and thank you for it. When we do have those chronic locations, and again, I just want to recognize Mayor Adams and Commissioner Agarwal at DEP, because this has really improved under their tenure. The agencies, or the police department and the DEP, working together with these joint operations. And again, blending the skill sets of both departments really well, where we can go out and do the technical work, we can do the measurements, we can issue to the offending parties at the higher rate of penalty, whereas the police department is helping us safely access some of these locations. We do not have armed personnel, so it is very important that they stay safe. So it has really been a wonderful blend. If you have locations, you should please provide them to us, because we are constantly on the move with these joint ops.
Yeah, normally it's neighbor and neighbor who say, well, they're playing the radio too loud, that kind of thing. But the police increasingly now cannot handle this. That's why, but I'm also wondering, with all this package of bills that we have, are 65 inspectors enough to handle this load here now? Because I don't know how you promote the awareness of the citizen noise complaint program, because a lot of people don't know about it, and maybe we would get more people participating rather than the bad actors that you say they're doing it for profit. But it's not under the, if we did promote this more, we might get really to the point where enforcement is, and we do have, enforcement is good, and we do have a livable city. But right now, again, I can't get the police to handle parking summonses anymore in my district. It's so bad because of their handling increased 911 calls.
Yeah, that's a very sensible recommendation, and we agree that we could do a better job of marketing this. I think we've been a little reluctant. We're holding off because we'd like to make these reforms first so that we can ensure that we have a successful program to promote. So we would greatly appreciate working with you.
And I like the strategy. Let's get the program to where it'll function properly, and we can get some of these issues solved, whether through legislation or regulations. But I do like the idea, but I would like to see the program operate, and because I'm dealing with the same locations over and over again, and I did speak to the commissioner about this, but I do, on chronic locations, I recommend DEP, because that'll put an end to it. You get a few $1,000 fine, you're not going to be playing music very loud constantly every night or just on weekends. So I like that idea. So, but do you need more inspectors? That's what I'm, because 65 for the entire city of New York, and noise seems to be one of the biggest complaints on 311.
Yeah, it's a tough question to answer during these budget constraints. We do feel like we have enough to respond to the complaints that we're getting within the mandated timeframes through the mayor's management report. We're always meeting our targets. However, additional staff would always be welcome. Clearly, we would put them to good use. I will say that in recent history, we've been working much more efficiently We're working smarter. We have utilized technology to our advantage. We have heat maps. We call them the heat maps. They're generally when we can see complaints coming in. Our supervisors can see that in real time, and they can deploy people to those areas. So yes, we feel somewhat constrained, as all agencies are now, but we do feel like we are working as efficiently as we possibly can, and through the use of technology, there's probably room for additional improvement.
Right. Let me just go back, and last question, I promise, Chair. One of the biggest complaints we get, and probably the most frustrating because the police can't catch these guys. The guys that play their music very loud in the car, and they ride around, and they wake the whole neighborhood up. And they even set up this, it's so loud, not only with their mufflers, but they're setting off car alarms as they drive down the street. A camera program that would catch these guys, you know, again, as long as we don't identify where these cameras are, you know, like if people know that where the speed cameras are, so they'll drive down every other street, but they'll avoid those streets or at least slow up. Are these cameras hidden? Are they noticeable?
They're hidden in plain sight.
Okay.
We have had a circumstance where one was detected, and absolutely it was avoided. There's a lot of clubs, these automobile clubs. They got the word out really quickly, and we were able to get there, and we moved the camera as quickly as they were able to identify it. So we do try to disguise them, and we do keep the location secret.
Okay, but I'm just offering my budget, a portion of my budget that I get in my council office for these cameras, because I think they'd be a godsend for peace and quiet, and we need to sleep at night in New York City. Thanks so much.
You're welcome.
Thank you, Councilmember Holden. Pardon me. I'm going to take some water. Okay, folks saw me having a sidebar with Alyssa Preston about an appeal from a citizen enforcer or versus Jackson Hole Restaurant. And the appeal was dated July 27th, 2023. And by my reading of it, it's pretty plain language. It seems to indicate quite clearly that, with regard to sound that is emanating from the interior of an establishment, and that 24-244B is the wrong section of the code for that. It's really meant more for outward-facing speakers if you're trying to draw people in for, as I said before, coming in by neckties here or whatever. And so with this having been put forward by oath in July 27, 2023, the question would be, it seems to me that oath has established that 24-244B is the wrong section of the code for the citizen enforcers that are coming forward with these violations. Now with this in place, and this also seems to clash a little bit with the August, whatever it was, resolution of the board that says, okay, if we can establish that the infraction or the problem or the violation has been fixed, then we're not going to levy a penalty. And so in July, it says it's the wrong section of the code for this kind of violation. In August, oath is saying, well, as long as you can show that it's fixed, then we're not, they don't seem to, they don't seem to agree with one another. But I'm going with the July one, because it just plain old says that it's, the wrong section of the code. Now, if I'm DEP, and I get the ability to, dismiss violations as frivolous or whatever the term is, if you're using the wrong section of the code, then why not just squash it there, rather than just not act and have the civilian enforcer go to oath, have the person default, 59% default, and then the city gets its money, and then the bounty hunters get their money. It just seems that this provides some clarity as to that section of the code being the wrong section of the code that that is being used by the civilian enforcers. And so that's kind of my statement. And so the question would be that since this has happened and there's been some clarity made that this is the wrong section of the code, has DEP changed the number of violations that it is dismissing from the civilian enforcers when they're presented to DEP based on this, appeal by oath, saying it's the wrong section of the code? And what is DEP's sense of this whole thing being like the wrong section of the code, and why, I don't want to make characterization, why is DEP sitting back and letting these things go through to, and tying up oath and getting the business owners to come down there? Most likely not. 59% don't. And so it's, forgive the cynic in me, that it's money for the city, okay, and then money for the bounty hunters. I don't get it. And so I would just like someone to opine on what's going on here when we have a document in hand, by my interpretation, showing that that section is the wrong section of the code for all of these violations that are being put forward by the civilian, or by what I call the, by the civilian enforcers. Some people call them citizen enforcers. I prefer civilian enforcement enforcers. So that's my statement, question. So there you have it. I don't want to be you right now, but sorry.
So thank you for that. We are aware of the appeals decision that you're referencing. I think it's important to draw the distinction that...
Oh, if you just speak right into the mic like this.
Sorry, is that better?
Yeah, yes.
So yes, we are aware of that appeals decision. I think it's important to point out in that particular appeals decision, the court focused on the fact that they were using it for the entertainment of the dining population, and they also pointed out that that particular location referenced in the appeal was near the Grand Central Parkway, so it was very hard for the citizen to prove it was for a commercial or business advertising purpose.
No, just stop right there. I'm not following that line of. I'm
going to explain it to your point. So I think it's helpful, that appeals decision, because there's no longer a presumption that just because it's audible that they're innately in violation of 244. So what DEP is doing is we're reviewing, as we have been.
But I'm going to take issue with that, because just plainly audible, whatever, gets into the whole, that's something that we put to bed 20 years ago with the noise meters and all that. And so that's what we're supposed to be doing. And so the whole plainly audible standard, which is like the unreasonable noise standard, is harkens back to a day before we did the noise meters and all that, and we put that to bed 20 years ago. And so I can't get past that.
So I understand your consternation. So 244B is in the code, and that does have a statement that basically it must be for commercial or business advertising purpose. DEP... Advertising
purposes.
Right.
So 244B is for advertising purposes. But yet all the bounty hunters are going there, putting their cell phone or whatever the hell it is, right up against the glass. And, DEP could have been dismissing these things from the get-go. And why weren't they before? And certainly, why are they not doing that now?
So we are dismissing a great portion of the citizen complaints that come to us based on lack of appropriate evidence, but we have not been opining and adjudicating whether or not, what the case specifically is.
Yeah, but certainly DEP is in a position to know whether or not the wrong section of code is even being applied, doesn't that give, if someone comes forward to DEP, complainant, and then they have this, so did they come with you with a ticket, or they just come to you? Or they come to you with their homemade
They
ticket?
come to us first. We have 30 days in which to review the citizen complaint. For a portion of them, we determine that we don't believe that the evidence is sufficient for anybody to pursue that complaint. So just based on...
Do you have any kind of statistic on, for the civilian enforcers, how many come to you that have been dismissed by, or whatever the word is,
Yes, we have that number. So, Melissa, if you want to report that. But ultimately, I agree that since we have these decisions now, I think that we do, and you're making that point, that we probably have the basis of more dismissals. And we can do that. That takes staff away from DEP's other business, but we certainly, based on what we're trying to do to support our local economy and our small businesses, now that we have these rulings and decisions, we can probably dismiss a great deal more. But also the reforms that we are proposing, I believe, will eliminate this problem in the future. So
and certainly that's a good conversation, but right now we have a situation where 59% of the businesses get these things, they don't show up, they get whacked, and then the bounty hunters get all their money, $660, whatever, and this is, by your own testimony, and the strong language in your testimony is a real blight and a real problem and a real, imposition on businesses in the city. And, we in government just don't really have the, don't have the luxury of just putting, harsh language in testimony when DEP comes before the council. The whole idea is to, once these decisions come forward and they're moving the needle on what is and what is not a valid violation, then DEP not only has the right but the obligation to make sure that it steps up and says, okay, we can do, we can come down harder on these, and then that has a chilling effect on the people who are writing the violations in the first place, because they're like starting to get shut down and shut out because they're using the wrong damn section of the code.
We can dismiss based on meritless and frivolous. I believe that's the language of the section, and if we determine, it's just very, very difficult sometimes by viewing those videos to determine what the intended purpose is of those speakers. It's just difficult for us, and there's that blurry line that we don't like to cross, which is that we are not the adjudicating body. That would be oath. So that's the fine line that we're walking.
I'll put that under the category of what I call nice try. You know what I mean? And I would have said the same thing if I were you. But, the fact remains that, and again, oath too. They got this thing in July, and then they got this thing in August that don't appear to me to sort of agree. But both are kind of, in different ways, sending the message that we're sick of this nonsense. We don't want to do this anymore. We got businesses getting jammed up. We got people walking away with like pockets full of hundreds of thousands of dollars a year from this, and we're helping them essentially, perpetuate a scam. And this can't be. And I wouldn't want to be part of DEP top management that's got to, shift resources in order to, make this thing go away. But, it sort of is what it is. And the people who are paying the price is not DEP, it's these businesses that are getting these violations. They don't know what they are. They don't want to hire a lawyer, or they don't know, or whatever. They're trying to run their business. Got to take a whole day off and go down there. They don't know what they're going to face. if I hire a lawyer and do this, I'm just going to break even anyway. So why don't I just pay the VIG, so to speak? VIG is a slang term. Most people might know what that is, but you know, those my age and older would probably know that. But so this is my, you know, this is what I get from, because people know I'm chair of the committee. I get businesses from all over the city like yelling and screaming at me, and then I get the bounty hunters yelling and screaming at me with their, you know, very aggressive tactics and you know, being, you know, aimed at my staff, and I'm like, what the heck are we doing here? And so happy to work, you know, going forward with, you know, things that we could and should do, but I think there, you know, needs to be a change, and it really needs to be a change now. And so, you know, whatever you need to do in order, well, you tell me what you think is going to happen now. After, you know, you're going to go back to left rack and say Gennaro did his whole thing. And so
we're riled up too about
Yeah.
this. I mean, there have been, again, a lot of conversations with small business services. Our colleagues over there are very frustrated with this program. And again, I think the best thing that we can all do is move quickly on this package of reforms, additional.
I know, but
reforms
right
that we
now, there are people, you know, there are people interacting with DEP today on behalf of the number of summonses is like off the chart. And so, all for the reforms, but I'm like, what we have in hand right now, you know, appeals of oath, the resolution of oath, and it would appear, that this appeal and this resolution came forward. I don't think DEP has really changed the number of you know, violations that they themselves are taking the opportunity to dismiss as frivolous or whatever the word is, or not consistent with the code or whatever. Or has there been a difference? If there has been a difference, a difference, now's the time to say it, and I'll be the first one to applaud. You know, but has that been the case?
You know, as I said, I think now we have a greater opportunity to dismiss some of these cases.
But the time is now. Like, this is July.
And the time is now. There's nothing I can do about pending cases with oath. So that's a clear.
Well, I think, you know, once we do something, those that have not been adjudicated, you know, we could tie all those up in a bow and just get rid of them. But again, I don't want to play lawyer here, but you know, to the extent there is this kind of you know, this kind of you know, injustice in the name of justice playing out in the city, where you know, business owners are getting fleeced, and you know, DEP has, you know, decisions in hand and can just, you know, kind of, you know, nip these at the bud and not drag an oath, which is clearly sick of this. And I think that's the obligation. I think, and you know, in the meantime, we work through like what we're going to do in terms of, you know, reforms, both, you know, to the civilian enforcement for noise as well as idling, which we're not really talking about today. You did in your statement, and I thought it was important for you to do that, and so I gave you a little latitude on that. But I'm kind of like decoupling, you know, officially decoupling, at least for now, because, you know, this is the fire that is raging, the one right now, with the bounty hunters and with the businesses, you know, with the businesses that are being impacted by it, and you know, government kind of throwing up its hands a little bit, saying, yeah, we could do more, but you know, we're busy, you know, and that just, you know, in the case of this kind of wildfire, that doesn't sort of carry the day, you know, it's just not good enough. I still like you all, you know what I mean? It's not about that, you know, but just, I think we need to do better. Let me see what other, hang on. Oh, my very patient partner in government here and partner in the council, Lincoln Ressler.
I thought you were going to call me loquacious.
What's that?
I thought you were going to call me loquacious.
Oh yeah, you're that and more, my friend.
I'll be brief today.
So you thought I was You thought I was a tough customer. Okay. You're going to get it now. Okay, so I recognize my friendly colleague, Lincoln Ressler, for questions.
Thank you very much. I'm not giving anybody an overly hard time today, but I do really appreciate Chair Gennaro's leadership on this topic and comments of my colleagues. You know, there is a noise complaint to 311 every minute of every hour of every day for the year, across the year for the city of New York. We get, I think there were 523,000 complaints last year. And, you know, we get it. We live in a loud city, and we're accustomed and acclimated to a certain extent of it, to a certain extent. But in many areas, it is just inexcusable, and it's very challenging to get any kind of meaningful enforcement from DEP or from the NYPD. I recognize that I think of those 520,000 complaints, only 60-something thousand of them get sent to DEP. The vast majority of them go to the police department. So we should bring them in next time, Chair Gennaro, and give them a hard time about their failure to enforce on any of the noise complaints that we have across our district. The stuff that drives me the craziest are the extremely loud mufflers, the extremely loud motorcycles that ride through our communities and have no regard whatsoever for our neighborhoods. And I'm interested in just understanding where we are on the camera pilot study and the status of your plans to expand it. My recollection is that you've had it at 5 different locations over the past year and a half. We had at some point been approached about identifying locations in our district that we thought would be viable. We suggested a number of locations. None have been selected as far as I know, much to my chagrin. And we want you to have a presence in our community and to be utilizing this technology to impose fines for people who are incredibly disrespectful of our neighborhoods. And so how are we doing on this pilot? Are we finally ready to acknowledge its success, its efficacy, or lack thereof? And what are the plans for expansion?
Well, thank you very much for the question. We really are pleased with the noise camera pilot program. This all began during the pandemic, or at least we saw our roads being overtaken by a lot of drag racing, loud mufflers, and it was very difficult to be able to deploy personnel in all of these locations simultaneously. It was frustrating us, it was frustrating NYPD, and we read about a program that was successful in London. So what we did is we sent over for one of their pieces of equipment so that we could pilot it here in New York City. We are extremely pleased with the level of precision of the microphones that are associated with the cameras. They are directionally oriented so that you can really pinpoint and discern which is the vehicle that's creating the noise. That's not in all cases. In some cases, it is not easily discernible. We don't feel like that would hold up in court. But we are pursuing quite a large volume of these associated just with the one camera. So we had about 250 summons that were issued so far. We have about another 100 that are pending. And I was reporting earlier that we have 9 cameras in total that were purchased, and we just finished installing 7 of them. So the other 2 will happen in the next couple of weeks.
But none in District 33?
I have to check. We have not excluded you purposefully. I honestly would have to check. But we
you haven't purposefully excluded me. But I hope that you prioritize our district, because downtown Brooklyn has a phenomenal amount of noise, and we could use some attention, especially by the entrances to the Brooklyn and Manhattan bridges. The levels of honking, the noise of the cars, it's extraordinary. And there should be more attention there. And I don't think, I would love to see more PD enforcement on this, but I don't think that that's the right solution. I think that the cameras are a better approach. appreciate that you have 9 cameras. Are we in a position where we could allocate capital dollars in this year's budget for additional cameras in our district?
It's hard for us
How do we get you to say yes?
to mix capital money with our expense budgets, so that
We purchase cameras with the NYPD, Argus cameras, in high crime areas in our districts to try and make sure that our police departments have the tools they need to be successful. Why couldn't we do the same here?
I'm very welcoming of the idea, and if we could figure out a way to do that, I would definitely support it.
I don't know that DEP takes capital money from the council, but if we could identify an alternative agency that could be a partner, so that we could purchase cameras and place them in locations that we jointly determine are most helpful, then we could help expedite
Excellent.
that. Do you have any sense of what the cost would be per camera?
Yes, we were just talking about that earlier too. It's about $35,000 per camera, and I will say that they are paying for themselves. So they are a wonderful use of technology. Again, we are not a profit-driven enterprise. We don't run on quotas or anything like that. But given the quality of life disturbances that this creates, I believe it's a very effective enforcement tool.
Okay. I would really like to follow up with you, Deputy Commissioner, about how we can be ready in this upcoming budget to allocate additional capital money to bring additional cameras to our district. So we'd like to start those conversations quickly. And then just lastly, as Chair Gennaro gives me the hook, in light of the passage of the SLEEP Act, the New York SLEEP Act up in Albany this year that went into effect last year that went into effect in April, enforcing decibel limits and raising fines for illegal muffler modifications, has there been any additional DEP enforcement or any ways that we can demonstrate that we've been able to execute on the efficacy of this law?
I'll let Alyssa handle that, because we want to differentiate between the vehicle traffic law and the enforcement of the DEP's noise code.
Yeah, I was just going to add that the penalty is $800 now, which we were able to do as a result of the SLEEP Act in March of 2022. Before that, it was around $250. So that did give us the authority to be able to increase that penalty. We refer to the VTL to set the sound limit that we use for the camera, but the authority for us to implement the program is purely within the New York City Noise Code.
Great. And so I look forward to working with you on capital allocations this year. We will figure out however we can make that happen. We would very much like to see an increased presence of these cameras around our district, and I imagine many of my colleagues would want to do the same. Thank you.
Thank you, Councilmember Ressler. And we have no more questions for the panel. We really appreciate your, being here, and it seems like the message kind of sunk in. We're appreciative of that. Look forward to the work, coming ahead, that we can, work on this with the noise and also the civilian with the idling, which we're not talking about today. But we do very much look forward to that. Always a pleasure to see you, and thanks very much for your good testimony, and so thank you. And with that, we have our first panel. If the council could call the first panel. No, hang on, just 1 second. Okay, we have a first panel of Andrew Ridgie, Max Bookman, and Robert Bookman, all testifying on behalf of the New York Hospitality Alliance. Well, you can work with, you can. Okay, I'm going to call upon counsel to swear in this, swear in the panel. And how much? What have we? Okay, Sergeant, normally we set it at 2. This is like a juicy topic. We're going to go to 3 minutes, give people a chance to say what they have to say. Even though that means they don't have dinner tonight. No loss there.
I can't say my name in 2 minutes.
Yeah. These people, are they up here? Now, that said, people don't have to take up 3 minutes if they, What's that? Did we do the swear? Did we do swear the minute? Oh, okay. Yeah, we just swear in the administration, those folks.
Okay.
So please proceed with your good testimony. We appreciate you being here.
Excellent. Thank you, Mr. Chair, council members, committee staff. My name is Andrew Ridgie. I am the executive director of the New York City Hospitality Alliance. We are a not-for-profit association that represents thousands of bars and restaurants across the 5 boroughs. So first I want to thank you both, Chair, Council Member, for introducing legislation that will put an end to the unacceptable abuse that far too many bars and restaurants have been subject to by a tiny group of self-interested private bounty hunters. These bounty hunters are not your average citizens. They've turned profiting off the backs of small business owners into an opportunity. They wake up, they go across the city to different neighborhoods, and they target small businesses. Worse, they're relying on an incorrect reading of the law to do it, as was recently recognized by OSA Appeal Unit, which was referenced earlier. They repeat this process over and over again, enriching themselves in significant sums. This is not how New York City should do sound enforcement. In a moment, you're going to hear from the Alliance's counsel, both Robert and Max Bookman. They'll speak a bit about the history of sound enforcement and the correct law that governs here, as well as some comments on these specific bills. But first, I'd like to say Councilmember Holden's bill will clarify that the correct statute for policing commercial sound violations is the one that has been on the book for nearly 2 decades and which you are very familiar with. The one that provides objective criteria based on a decibel reading. It would send a stark message to the bounty hunters victimizing bars and restaurants that the section of the law they are currently using to go after small businesses is off limits. Second, for those who may not get the message, Councilmember Gennaro's bill would cap the amount of money bounty hunters could collect from initiating these summonses. But after listening to DEP's very thoughtful commentary on this matter, it seems that the best idea may just get rid of the section entirely of the noise code that permits civilian complaints and these bounty hunters to go around and exploit small businesses because of the degree to which they're doing it and some of the really incredibly horrible techniques they are using. There were some comments we had about limiting the ability of a citizen to live within 200 feet of a business. to be permitted to issue these violations, but perhaps the idea is just get rid of that section in its entirety. But also, we want to make sure that the thousands and thousands of these summonses that are currently pending are tossed out as well. So we'd love to see a provision that not only applies moving forward in the future once the law is enacted, but also to ensure that all of these summonses that are pending are tossed out. So for these reasons, the Hospitality Alliance strongly supports these efforts, and you'll hear from my colleagues at the Hospitality Alliance in more specificity. But I want to thank you for your time and your effort to address these issues. If anything, you both know that we need to support our small businesses, and what's happening here just sends absolutely the wrong message to not only our small business owners, workers.
Thank you, Anthony. I got to move forward. And the way I want to do this is, I just want to pose a question. You made reference in your statement to Mr. Bookman that was going to give us some legal commentary. Let me put that in the form of a question. Mr. Bookman, if you would opine with your very substantial legal background going back. You were part of this 20 years ago. And so if you just take us from 20 years to now, give us some legal commentary on what you saw play out before us today.
Sure. My name is Robert Bookman. I'm counsel to the New York City Hospitality Alliance, but I'm also a partner in the small Manhattan law firm, Pazetsky & Bookman, and we specialize in representing small businesses and have been doing so for 35 years now. So you're correct. About 20 some odd years ago, you and I were both involved with the once-in-a-generation change of the noise code. And you did an excellent job as chair of the committee at that point, bringing in all the stakeholders that were going to be impacted by this new noise code. As you said before, there was construction, there was garbage collection, cars. One of the last sections, actually one of the last things that remained, was the hospitality industry commercial noise. There had been on the books for a long time what was called an unreasonable noise standard. It meant, as Councilman Holden said, anything anybody wanted it to mean. So it meant everything and it meant nothing. And businesses were complaining that the default violation from the NYPD when they went to a place was issue an unreasonable noise summons. It invariably required you to hire a lawyer, and they all got dismissed, but they would be used against you when your liquor license was up for renewal, that you had these violations. And we brought that to your attention, and we had one specific request, and that is that there be an objective standard for the measurement of sound emanating from a commercial establishment. It didn't seem complicated. Noise is one of the things that, in fact, can be measured. And thanks to you, you told the administration, Mayor Bloomberg, and the chairman, Emily
Lloyd,
Emily Lloyd at the time, that unless that issue is resolved, you're not passing the noise code. And if you recall, it was at the end of a session, and if they didn't pass it in December, they would have to start all over again. She went to Emily Lloyd, Commissioner, went to the mayor and explained the problem, and as it is now well known in folklore, the Mayor Bloomberg, who was a techie kind of person in his day, said, "So what's the problem?" And she said, "Well, if there's an objective standard, every police department and DEP will have to have a handheld noise meter." And he said, "So go buy them." And that resolved it, and we passed a specific criteria that, as you recall, which requires a certain amount of decibels above ambient during the day, a different one, a lesser standard at night when people are entitled to more quiet. And we have lived happily ever after for the last 20 years where we have not had these unreasonable noise violations, but businesses know with a couple $100 they buy these handheld meters, and they measure themselves pursuant to the law when their sound is leaking from inside, which it often does when you're playing background music for patrons and you have windows and doors open, but they can measure it for themselves.
I was just going to say that because I'm the chairman, I'm not subject to the clock in terms of the answer to the window.
And that's been the standard objective criteria, not subjectivity, for 20 years now, until these bounty hunters found a 1972 section of the noise code that I am embarrassed to admit I did not know exist. I'm not sure you did either, which...
Nor did the Bloomberg administration in 2003
No, nor did the
either.
Bloomberg administration, nor did the Commissioner Emily Lloyd, which apparently was put in before there was a 311, before community boards were even really being established, where people didn't have a way to complain about noise. So this was put in there that if you were a true citizen and wanted to complain about, somebody downstairs from, or around the corner, on a commercial strip in, in Queens or in a building underneath, there was a mechanism to do it. No one knew it existed because it was virtually never used until these bounty hunters decided to abuse the system. And to answer the second part of your legal question, they were abusing it in an improper way because they are citing the section of the law which we clarified, or at least we thought we clarified. But I think we need Councilman Holden's bill to make it crystal clear in black and white that what we meant and what has been happening for the last 20 years be the law for the next 20 years, and that is a specific objectable criteria. So that solves that problem, but it doesn't solve the bounty hunter problem, which is new to me. As a matter of fact, the first time we started hearing about this last November, we quite frankly thought it was a scam that somebody was trying to collect money from a restaurant because it had no name on it. It had DEP crossed out. It had some P.O. box. So we told people ignore it. And then when we started to get a lot of them, we went to DEP and they said, yeah, no, it's just a section of the law that nobody knew about, and there are these guys issuing tons of them. So that's the noise code issue and the citizen complaint history, legal history, how we got to where we are today.
Let me get to my next question.
Sure.
And, thank you for your indulgence in keeping you up here, but,
keep me here.
we've worked on this stuff a long time, and now, with regard to the oath appeal of July 27th, I, as a non-lawyer, and the counsel to the committee, seems convinced that this kind of rules out, 24-244B as an applicable section of the code to be used as the bounty hunters are using it. Do you believe that this appeal is, very dispositive of that legal fact?
I do, and I do want to say that I was very impressed with DEP's testimony here today, how they are complete support of Councilman Holden's bill. They provided plenty of support, for your bill. I'm frankly shocked that the situation is even as bad. It's worse than I thought it was, where only 6 people have filed these citizen complaints, and 2 of them have 90% of them, and only 6 have filed more than 1. It's really, really a bad situation. So if they felt that they were constrained by this 1972 law, which allowed for bounty hunter complaints before this appellate decision, and I disagree with them about to what extent they are an adjudicator under this law. It's true when DEP issues a summons, or Consumer Affairs, or any other agency, they are the plaintiff, but this law provides for something different. And so this law did not allow for, quote, citizens, and I put it in quotes because I don't even know if these 2 people are citizens of the city of New York. We don't know where they live.
That's why I call them civilian. That's why I prefer the term civilian.
I don't even know where they live. They could live in Long Island, as far as I know, and they're just making a living here in New York. But it gives the agency 3 options. They can't just go right to oath, and submit a violation. It created a different process, and that process is DEP has 3 options. They could say, hey, this is a really good violation based on the amount of evidence we see. We're going to take it over as the petitioner in the normal course of a violation. Or, we think it's a little bit weak, but you citizen bounty hunter could proceed with it on your own if you want. But the third option, which they kind of ignored until you asked them the question, was they could dismiss it right out by finding that it's frivolous or duplicitous. So the law does require them to have a judicial role here, basically. you know, because it's different. It's somebody sending in a violation, and they should use that judicial role judiciously. And they certainly, before July, were not, because we now hear that 6,000 of these went to oath, which is an outrageous number. Now comes this decision of July 30th, whatever.
Yeah.
I'm kind of disappointed that DEP, that oath felt constrained not to be able to answer any of your questions today. But if you read that appellate decision, they are basically reaching out to DEP and to the council to do something about these thousands of violations. It's their Supreme Court, and it is binding upon their other ALJs, and Max will speak to whether the ALJs are informed about this decision.
If I ask him to, he will.
He has appeared on these violations since then. But this appellate decision is very clear-cut. It gives DEP all the ammunition that it possibly needs. And let me read what we call the holding in the law, you know, where the court says, okay, here's the facts and here's our legal decision. It says, quote, where music contributes to the atmosphere of a dining establishment or a store and is directed to the patrons or shoppers therein, even though it may also be incidentally heard by passerbys, an advertising purpose is not established. And that section of the law that these bounty hunters are writing it under is a section that talks about commercial advertising.
Right.
The old Canal Street, you know, hawkers where they're standing out there with a microphone or a megaphone. That's commercial advertising. The oath is saying here that restaurants, stores, bars that are playing music for the enjoyment of their patrons, even outdoor patrons, because this appeals case, by the way, the speakers were outside, but they were facing their licensed outdoor dining area. Even in that case, oath is saying wrong section of the law. So DEP can tomorrow and should tomorrow review all the violations that have not been fully adjudicated yet, and there may be thousands of them, all the ones where there were defaults because they could all be opened, as we heard today, and apply this new standard where the court has made clear that that's not a commercial advertising purpose, and therefore get rid of a whole bunch of these before you guys even pass a law to limit, you know, the bounty hunters.
Now, in order to do that, if there are indeed thousands, you know, DEP, although they did bring up the resource question. It's just like, okay, we have to suddenly pour through thousands of them, and you know, how are we supposed to do that? Like and I, you know, you heard what I said, but I
said nice try.
Yeah, but there, you know, there are resources that you know, in all candor, there are resources that would have to be applied to do that. But as I also said, that they have, you know, not only the right, but they have the obligation. And you know,
perhaps
just because the workload is a lot is not an excuse for not doing it.
Correct. And once they start dismissing all of these as Councilman Holden, I think, said, the volume is going to go way down because these guys are owning it for the money. And if they're not going to get the money, then you know, yes, initially there may be thousands, but in 2 months from now there may be hundreds, and 2 months after that there may only be dozens. Right. They'll do something else to make a living. Also, you know, DEP is not completely an innocent bystander here. They got to put in the work, but they're also getting a cut of the action here by not doing the work. And, you know, they don't have clean hands.
Well, the city's getting
well,
money.
It goes into their monthly report or annual report about fines that have been collected, and this is an easy, cheap way for them to collect fines because they don't have to do any work. They just say, okay, you bounty hunter, you prosecute the case. They don't have to put in any of their inspector time, any of their attorney time. You know, maybe Oath will, you know, we'll lend them a couple of ALJs to go through some of these. Also understand that DEP has a citizen complaint noise form that goes with these citizen complaints, and it is wholly lacking in requiring these citizens to put in sufficient information for DEP to make a determination. It doesn't ask what is, a simple question, what is the commercial advertising purpose that this noise was complaining about?
Oh, you're saying that the form should properly reflect the section of the code that people are...
And this appellate decision, and there were other court cases going back 20-some-odd years ago which talked about this. If this is all they're looking at, of course they're passing all of these along because they're not asking enough questions from the bounty hunter.
Do we have that? Do we have that form? Okay. I mean, when Sergeant, you don't mind giving us that. So, Sergeant, when they leave the dais, I want that for the record of the committee. And if I could, just to move things along, just to move things along, I'd like to ask Mr. Max Bookman if you have anything to add what Robert had to say.
Yes, and thank you.
You want to speak right into the microphone with the red light on.
Thank you, Chair, and thank you, Councilmember Holden, committee staff. My name's Max Bookman. I'm a partner at the law firm Pazetsky & Bookman, and for the past 8 years, I have been representing small businesses before oath. No small business should have to go through the time and expense of hiring me to defend them at oath for this type of violation. The abuse of these summonses, it's not delivering justice, it's creating injustice, along with wasted time and money. Chair, you said to DEP you want to decouple the idling violations and the citizen complaints for those from the noise violations. You said we have a fire, we have an emergency going on with the noise violations. So what I'd like to do is I'd like to give you a report from the trenches in Oath, where I practice, and give you 3 of the aggressive tactics that these incredibly small number of individuals are using to misuse our city's summons apparatus. One is that they're ignoring oath precedent. The appeals unit case that we've been talking about today was issued on July 27th. These citizens are still prosecuting these cases. And when you go into the hearing, the virtual hearing room with them, they're not bringing up this appeals decision with the oath ALJs. You asked, Chair, whether the appeals unit decisions are disseminated to the oath hearing officers, to the ALJs. Well, they're supposed to be, but we've had many hearings where the oath hearing officers are unaware of this decision. So our clients are fortunate to have us. We're aware of it. We bring it to their attention. But not everybody has us, and not everybody is hiring a lawyer or a lawyer who knows all this background. And so if the hearing officer doesn't know about the appeals decision, and if the citizen complainant is not bringing up the decision, it's just going unmentioned. So that's a major problem. You know, in state court, there's a duty of candor with the court. You have to be forthright with the court about the legal arguments that you make. There's the same expectation in oath, and it's not happening there. So that's problem number 1. Number 2, not only are they ignoring the oath precedent, but they're issuing multiples of these frivolous violations one day after the next. And I'm glad to hear DEP talking about it because it's really a problem. So just to give a little more color on that, these folks are coming unannounced. They have no badge to show, but they're not, once they do come unannounced, they're not making themselves known. So they come day after day in secret, recording businesses day after day, issuing summonses day after day. We have one client in Oath who got 7...
But they don't serve them. They don't serve
them right there. No, they take their video, they go home, and then they submit the complaint form to DEP. So we had one client who got 7 of these in a 20-day period and didn't get summons number 1 in the mail until after, turns out, summons number 7 was issued. So it's like there's a delay here. They come, issue 1, 2, 3, 4, 5, 6, 7, and then, 20 days later, 30 days later, 60 days later, now in the mail, they get summons number 1, and then the next day, number 2, 3, 4, 5, 6, 7. So what legitimate purpose is this serving? DEP talked about education. There's no legitimate purpose to this. And lastly, the third, aggressive tactic that they're using is they're alleging recidivism. And this is so dishonest. Like many of your laws, 24244B has higher penalties for repeat offenders, which we call recidivists. But you're not a first-time offender until you've been found guilty of something. But it's not so with these folks. When they go on their summons spree, where they're issuing these summonses day after day, when they come to on the second day and every day thereafter, they're alleging recidivist, repeat offender fines in their complaints to DEP, which DEP then turns into a summons, or DEP takes no action. The citizen gets to issue the summons. So take my client who got the 7 summonses in 20 days.
Mr. Bookman, if I could just jump in here for a second. I just want to see who is remaining behind from the administration. Who's here from the administration to hear the good testimony that we're... Anybody here from the administration?
That's too bad.
Going once, going twice?
That's a law we should pass. They got to stay to the end of the hearing.
Stay and listen to them.
If I could, Andrew, can you call Robert, Cataldo, and indicate that, it is my expectation that the administration has to have somebody in this room to hear this good testimony. Just step outside, give him a call. You got his number? Yeah. Okay. Like, somebody's got to be here like really quick, or I'm going to get upset. Okay. Please continue.
Thank you, sir. So just to finish the point, so you take my client who got the 7 summonses in a 20-day period. By the time that second summons came in the mail, they're already being told that they are a repeat offender, when the first summons they just got yesterday, and it hasn't even been adjudicated yet. And this is particularly insidious with these citizen bounty hunters, because the repeat offender fine, even just to settle it, even just to mail in a violation saying, I don't want to hire a lawyer, I don't want to take a day out to do oath, I'm just going to mail in the fine. Even the mail-in fine is significantly higher for these repeat offender summonses. So at minimum, I don't know why DEP is not policing that. It's not in their form. Are you saying this is a repeat offender? If so, state the date that the summons was previously adjudicated and provide proof of that. But we need to, it's just another example of these aggressive and dishonest tactics that we need.
But oath is part of this because they are, they're not disseminating these appeals and the resolutions, and they're, levying fines for repeat offenders when there has been no conviction or whatever you call it, no
right.
substantiation. So you happen to have it. So to the extent that you could give us, or not like right now, but prepare something for us that our legal counsels can look at, and we would like to make an overture to oath about your good testimony and about like what they're doing, and we want answers from them.
Thank you for that. Yeah, there does need to be, I think, better education of the judges at oath. Ultimately...
But we got a handshake, then you're going to give me you're going to summarize what you're saying, right? The item 1, item 2,
Oh,
item
yes,
3.
And that's what I'm saying. They ought to be...
That's the right move to go to oath, right?
Well, yes and no. Yes, the right move is to go to oath.
Well, you know what? I'll ask my own lawyers that question.
It's a combination of both, but also understand...
But just for my own edification, it would be good to
understand a lot of small businesses, they are overwhelmed with just running their business and trying to make a profit. They're their own HR department. Many of them are immigrants.
Just to follow this by the rules, because there are going to be other witnesses, and they're going to say that I gave you a lot of time. So what I'm going to say is, so in answer to my question, you were in the middle of a thought that was of interest to me.
Let me just finish that thought.
And what's that?
Let me just finish this thought, right.
I'm just saying that I am asking you to finish your statement.
Yes.
So this is being done in response to a question by me. Go ahead.
They get something from the government. It has a fine that you could just mail in. A lot of them just think that's what I'm supposed to do, and I just mail in the fine, even if it's a recidivist fine. They don't even know this sometimes that they can go down and defend themselves. And so oath, when these people get these things in the mail, it has a mail-in fine amount, right in on it. And so for a lot of people, it's the cost of doing business in New York City, is paying a certain amount of money to city government when you get violations. It's always wrong, but it's especially wrong when it's a citizen bounty hunter and they're getting a recidivist amount. So, it's not so easy just saying that oath should not institute the recidivist fine. That's true if you went through full hearing. Then the oath judge looks and says, well, you've never been convicted of anything before, so it's a first-time violation. But a good portion of these, 59% of defaults, another percentage are settlements where the person descends in the fine. Only a small percentage are actually going to a hearing.
I see. Okay, yeah, we had great collaboration 20 years ago, and I appreciate your advocacy on behalf of thousands of small businesses that are being set upon in a most unjust way, and it is. I, as chair in this committee and the council at large, stands for trying to do what we can as soon as possible to right this wrong, and I appreciate your,
Thank you.
Thank you again. Thank you for 20 years ago. Thank you for now. Thank you for joining the battle, Councilman Holden. I think together, the two of you each have half of the coin here, which we could solve this problem.
And there's some business owners here I know that have been victims of this.
Would love to come and testify. Some have to get back to work.
You know what? My colleague Bob Holden has a question for the panel. I recognize Councilmember Holden for questions.
Thank you, Chair. And just, I guess this is for Max, because you mentioned that some businesses were targeted multiple times and they're repeat offenders. What are we talking about in the way of fines? That they're like, what kind of nightmare stories do you have of one business absorbing thousands of dollars worth?
I've got one client right now who was here earlier but had to go back to their business, who is facing right now, because of the total number of these citizen issue summonses they've gotten, over $12,000 in fines. 50% of that goes to a citizen. So that's just the citizen.
Yeah, and so this is coming on top of the pandemic, where all these, especially, I had a barber shop that was, he didn't have like these little 6 feet markers on the floor, and he got hit with thousands of dollars worth of fine. He said, I only had one customer at a time. I'd make an appointment. And so I never had more than one person in my store, and I had to pay thousands. And we couldn't, again, they fined them, and we couldn't do anything about it. And this is egregious. It's particularly egregious when, on top of the pandemic and all the restrictions we had to close, to shut down, to only operate, outside, whatever it was that the business had to put up with, and then they have this now. And that's why I think we have to fix things that are unfair. God knows government's unfair, bureaucracy is unfair many times, and this is why things fall through the cracks. So I thank you for your testimony. I'd like to see even fine-tuning this further, where we give the businesses an even shake here. I'm not again, I have businesses that cause problems in the neighborhood, so we understand that, but they need some kind of measurement, and they need to know when they're breaking the law and not some subjective and arbitrary person.
And the last thing I want to say in response to you, I think the most important part of the DEP testimony, which was surprising to me, is they are saying that there is no court, that these places that are getting these bounty hunters are not places that are getting 311 complaints for noise. So this, it's one thing if these are, are trouble locations, problem locations in the neighborhood, where there's 100 311 complaints. This is just people, according to their map, they're walking around just wherever they can hear, a sound system, they're giving a violation, even though nobody's complaining about it. It's outrageous.
Thank you, Chair.
Thank you. Thank you. I want to thank this panel for your advocacy on the part of the business community and your commitment to making to bring justice to the business community. Appreciate it. And
next, we have David Sheldon with the South Street Seaport Coalition, Caitlin Mooney with The Independent, and Kathleen Riley Irwin with the New York State Restaurant Association.